With regard to property of the bankruptcy estate, you need to remember that property of the bankruptcy estate includes not only those assets that you own on the day that you file the bankruptcy, but as well assets that have been conveyed away within a certain period of time before filing the bankruptcy. It's very important that you don't transfer or sell an asset when you're in a financial pickle unless you speak with your consumer bankruptcy attorney first. If you convey an asset away, I recently had a client who sold an asset that would have been exemptable. The sale was perfectly fine. There was nothing that was fraudulent about the sale. But those proceeds then were just cash that weren't protected under the exemption laws. And the motor vehicle they sold could have been exempted or protected. If, however, you transfer something away for less than fair market value, part gift, part sale, or just total gift, let's use a quad for an example. If you have a motorized vehicle, a quad, and it's worth $4,000 and you don't want the trustee in bankruptcy or your creditors to take the asset, then you might transfer that asset to a friend to be able to protect it. That will not protect the asset, and it's called a fraudulent conveyance if that friend didn't pay you the fair equivalent value. If your friend paid you $500 for a $4,000 quad, then it's a part gift, part sale. If the friend paid you nothing for that quad, then it's just a gift. Remember, if you are not insolvent at the time that you make that transfer, then it could be argued that the trustee can't set that transfer aside as being a fraudulent conveyance. However, you need to it turns on very specific type of technical grounds. Get the benefit, avail yourself of the benefit of an experienced consumer bankruptcy attorney before you transfer anything, even if you're even considering filing for bankruptcy. Now, the property of the estate, the bankruptcy estate also includes assets that you've paid out to a creditor. That was an insider, if you look back 1 year, or not an insider, you look back 90 days. Let me clarify that. An insider is a business partner, a family member, someone who has a close relationship to understand what's going on. And if you owe that person money and you pay them within 1 year before filing for bankruptcy, the bankruptcy trustee can bring that asset back into your bankruptcy estate. An example, let's say I owe my mother $5,000 and I want to make sure she gets paid. So I take $5,000 out of my bank account, or I sell a $5,000 asset, or I simply transfer to her a $5,000 asset. Any one of those situations, if I filed for bankruptcy within 1 year of having preferred her over other creditors, the trustee in bankruptcy can file an action. It's called a preferential transfer action, and they can ask the court to reverse that transfer back, and therefore your family member will need to give that asset back to the bankruptcy estate. There are assets that you acquire after you file for bankruptcy that could become property of your bankruptcy estate as well. For example, if you inherit anything, or if someone gives you a gift within 180 days of filing your bankruptcy, it becomes property of your bankruptcy estate. If someone were to pass away and you were left as a beneficiary on the life insurance within 180 days, if the passing occurred within 180 days of your filing of your bankruptcy, then that becomes property of your bankruptcy estate. These are very, very, very critical things to bring up to your attorney. If you're considering bankruptcy and there's someone who likes you and someone who's likely to leave you something and they're sick or in the hospital, you might want to delay the filing of your bankruptcy until you receive those resources, and maybe it can solve your problem. Maybe you can do some pre-bankruptcy exemption planning. I know this video has been longer than most, but the bankruptcy estate is a critical part of any bankruptcy preparation, and I just can't emphasize enough that you need to speak with your bankruptcy attorney before you make any transfers or any payments to creditors within a year's time before filing for bankruptcy. One last thing I didn't cover, and that is a fraudulent conveyance. The transfer, like the quad that I mentioned, to a friend for less than fair market value. While the bankruptcy code requires that you disclose that transfer if it happened any time within the 2-year period before you filed the bankruptcy, state law will allow for a fraudulent conveyance action to be brought if the property was transferred more than 2 years. In other words, for example, in Arizona, the fraudulent conveyance look back is a 6-year period of time.